Chapter 13 of the textbook continues our study of legal research, this time focusing on finding and interpreting court opinions. As with Chapter 12, this is just an introductory lecture. It is not in any way a substitute for a careful review of the entire chapter. Chapter 13 is devoted to research about court opinions. These opinions may be interpreting statutes or may be matters of judge-made common law. The opinions that we read and in connection with legal research are almost always opinions from courts of appeal as opposed to trial courts. However, there are reported decisions by trial court judges that can be useful in conducting research, but cannot be cited as controlling precedent. It doesn't mean we can ignore these. Again, if there is no other authority on point, it's always good to look at a trial court judge's opinion and see how they've applied the law in the particular case. And for examples of where we can find trial court opinions include the federal supplement, which includes opinions from federal district courts. And there are a number of specialized courts that have reports of trial court opinions, including West Bankruptcy Reporter, which includes decisions by bankruptcy judges. All right, when we're conducting legal research, we need to locate the court opinions. And this is done in much the same way as we locate statutes in conducting statutory research. We look for the citation. The citation will include the name of the case, where it can be found. It usually includes the court that decided the case and the year in which the case was decided. Like with statutory reporters, appellate court opinions are also published in official and unofficial case reporters. These are included and published in online and also in hardbound volumes. The unofficial versions are often published by West Publishing, and with some states have no official reports, and the West Publishing series is therefore the only source of published works. In California, we do have official reports for all Court of Appeal and Supreme Court decisions, the Supreme Court of California. And there are also parallel reporters by West Publishing Company that contain the same opinions. So again, two different sources. In addition, most courts of appeal now publish their decisions online. So if you know the name of the case that you're looking for, you often can find it. However, it's not a real efficient way of conducting legal research because there's no real index apart from the reporters that are published. It's important to understand how opinions are cited, and there's a good discussion beginning at pages 350 of the textbook on how to read a citation. And in particular, I draw your attention to figure 13.1 at page 351 of the textbook, which takes you through the citation of the case of Callow versus Thomas, 322 Mass 550, 78 Northeast 2nd, 637, 1948. And again, this shows that the name of the case, the fact that it can be found in the official reports of volume 322, Massachusetts Reports, page 550, and also the unofficial West Publishing reports 78 Northeast 2nd, 637. And again, it was published in 1948. So again, pay particular attention to the discussion in the textbook. When we're looking at court decisions and reading them, and there are several of them in the textbook, including a very short United States Supreme Court decision, McBoyle versus United States, at page 372, and Texas versus Johnson at page 376. You'll see that typically the court decisions include preliminary material and editorial features. Oftentimes, this will include a summary of the opinion, followed by the facts of the case, a discussion of the law, the issues, the decision, the reasoning behind the decision, and finally, concurring and dissenting opinions. When we are conducting legal research, as we've discussed earlier in the semester, it's important to understand the difference between mandatory authority and persuasive authorities. And again, as we've discussed earlier in the semester, mandatory authorities are decisions of higher courts in the same jurisdiction. For state courts, this means the higher courts within the state. The California Superior Court judge is bound by decisions by the California Courts of Appeal and California Supreme Court. The California Court of Appeal justices are bound by decisions of the California Supreme Court. In the federal system, the federal higher courts are the courts within the same circuit and the United States Supreme Court. So a judge sitting in the United States District Court for the Central District of California is bound by decisions issued by judges in the Ninth Circuit Court of Appeals, where the Central District of California is located, and the United States Supreme Court. This leads us to the possibility, and it happens occasionally, where different courts of appeal may have different rulings, different circuit courts. So you may have a common issue of law and have the Ninth Circuit Court of Appeal rule one way, and the Second Circuit Court of Appeal rule another way. That's not tolerable if it's the same federal law, and that's oftentimes where you get the United States Supreme Court come in and make a ruling reconciling the differences. But again, both in the state and federal system, we have this concept of mandatory authority. Persuasive authorities, on the other hand, are not mandatory authorities, but they are decisions of an equal or lower court from the same jurisdiction or from a higher court in a different jurisdiction. So if a California Court of Appeal was considering an issue and another district Court of Appeal had considered that same issue, the decision of the other district Court of Appeal would be persuasive authority. It doesn't have to be followed, again, because it's the same level. Similarly, the California Court of Appeal may be reading or researching an issue, and there may have been an opinion written by a trial court judge about the same issue. Again, they're free to consider the reasoning of that trial court judge, but it's not mandatory. It's persuasive only. Another way that this might come about is, and it's particularly true in the Western United States, where California, we have a well-developed system of statutory law, and oftentimes you'll have identical statutes in states like Arizona or Nevada. So you could have the same exact statute in one of those states, and the Supreme Court, for instance, of Arizona, construing that statute and making a ruling. Again, a California court in considering that statute could look for guidance from the Arizona Supreme Court, but it is persuasive authority only. It doesn't have to be followed. Another example of persuasive authorities are in secondary sources of law, treatises, law reviews, and things like that. Okay. So again, when the courts are making their decision, they when looking at mandatory authorities, they will look for cases with the same or analogous facts, and in connection with their ruling, distinguish prior cases if they reach a contrary decision. Finally, again, judge-made law is common law, and judges do create new common law all the time. Obviously, new common law can come up in issues of first impression, where something has never been ruled on before, and a court is being faced with that. The other way a court can create a new common law is to overrule precedent. We saw that happen in the last Supreme Court session when the case of Roe versus Wade was overruled, and accordingly, new common law regarding the right to an abortion was enacted. All right. Again, in chapter 12 of the textbook, I asked you to cover the materials in parts A and parts B. We will not be covering in class or in the test the materials beginning at page 358 in the case briefing. You're, of course, free to read those materials, but again, they won't be covered. Again, be sure to review the first part of chapter 13, as I indicated, as you will be expected to know that for purposes of the test.